Chair, my submissions this morning to you will be that Ms. Myeni is indeed in defiance of a summons, and that is a criminal offence. Chair, the reasons I say so are the following. First, there is no affidavit before this commission from Ms. Myeni. It is trite that any explanation pursuant to a request for a postponement must be done on oath. It must be evidence. We have not even been favoured with an affidavit from Ms. Myeni explaining her position. That's the first point. The second point is that the only explanation we have been given from the bar by my learned friend is that when, through her attorneys, she asked on Friday for a summons to be stayed, and she did not receive a response, she thought she could not come today. Chair, that defies, with respect, even logic, because when the summons is in place and the compulsion power of this commission has been exercised, and you motivate for it to be stayed, and according to evidence from the bar, you receive no response, it is not sufficient cause for you then just simply not to appear. The assumption must be the summons stands. There has to be another exercise, Chair, by you. You are the functionary empowered to issue summons to compel evidence before this commission. On the version we got from the bar today, Ms. Myeni knew nothing of a further decision having been made on your part, which would be the only basis for her not to appear. Chair, we then heard, this is the third reason I say that she has committed a criminal offence, from her counsel this morning, from the bar, that yesterday afternoon he advised her that she must be present today. And then the fourth indicator is, again, that we've been told Ms. Myeni this morning was en route to a family engagement. Chair, there is no respect in which the summons that this commission issued for her to appear today has been taken seriously by Ms. Myeni. We're dealing with defiance. We're not dealing with postponements. But I may just give you the language of the Constitutional Court in the case of Psychological Society versus Pelani. That was a case dealing with postponement, and I'm reading from paragraph 30 of the judgments. Postponements are not merely for the taking. Well, today, the postponement has been taken.
I have to make this point, Chair, because I think it also works towards the integrity of the commission in itself, Chair. It's disheartening to observe how my learned friends, the evidence leaders, purport or seek to project this commission as a prosecution, whereas in the proper understanding of what this commission is about, it's a fact-finding inquiry where witnesses need to account and they need to come assist the commission. On arriving at this commission today, it's now going for 11 o'clock. We've lost 2 hours in engagements between 3 lawyers and
But that's because your client is not here.
Indeed so, Chair.
In defiance of the summons.
Chair, the submission I'm making
And
is
that
the
2
following.
hours is spent trying to establish why she's not here and what should be done about it.
Thank you, Chair. Where I was going to with that point here about the 2 hours is that, Chair, I was appreciative of the stance that the Chair had taken that said, if it's not an act of defiance on her part, what pragmatic solution can we arrive at to then solve the problem of getting her evidence on record? And we had departed here with the view of saying, granted, you may not be here, but if your indication is you do want to testify, you've testified online before, it gets us to the point anyone can testify online. Let's find a pragmatic way of implementing that. And since that suggestion, Chair.
Maybe before you proceed, let's start where we should have started. you spoke to her. Tell me what transpired, because from what Ms. Mayor said in terms of what she gathered from the conversation with you,
No, Chair.
it looks like she was on her way to a family meeting, but she undertook to turn back and go back. But
No.
then the story, I want to hear the whole story.
Chair,
What is your response?
that's the objection I raised, Chair.
Yes.
As in to say.
Let's start with that.
Yes, I think I was misunderstood by Ms. Hofmeyer.
Yes.
Sorry. When we took the adjournment, I then called her to say, what is your location and what's your availability for this thing to proceed online? She says, I am available. As I'm speaking to you, I should have been on the road to Potchefstroom, but that is not on the plans, and I will drive to the attorneys. So the U-turn story, she said, I'm on standby. And that's why I came back and I said we could be online and proceed within 2 hours. Because she then said, I will have to divert my plans of wanting to go to Potchefstroom later and go straight to the attorneys in Pietermaritzburg. So her availability to me on call to receive directions was informed by the fact I said, I don't know what the DCJ may direct or may not direct. I need you to be on standby so that if there is an amenability to resolving the situation pragmatically, then we can make it happen in the shortest time possible. So it was never an intention not to be available or not to be here. As already submitted, Chair, we came here with the intention to say, due to a breakdown in communication, we seek to find a pragmatic way of making the hearing proceed. And at every turn where we've said we want to make the hearing proceed, we've been blocked. When we said, okay, let's find a way of implementing a solution, the first objection was the fact that the documents will not be there on time. We take the adjournment to rectify that and try find whether we can go online. Now the objection is, no, we must lay a criminal charge. Well, if you lay the criminal charge, Chair, it takes us to this position, then the witness will never come.
This is the decision I have reached. One, it's not acceptable that Ms. Myeni did not comply with the summons and presented herself at the hearing this morning. Two, from what I have heard, there appears not to have been any valid reason for her not to appear. Three, the Secretary of the Commission must take steps to lay a criminal complaint with the South African Police Service against her for acting in breach of the Summons and the Commissions Act. 4, I direct that she should make herself available to give evidence today, whether it's via Zoom or any of the methods used for her to appear virtually. So that must happen today.